Hello, everyone. Welcome to Court with Krissy. When there's an attempt to end the attorney-client relationship after 24 hours, that's kind of like one-night stand status. But don't worry, folks. There's going to be a second date. He has warrants. I hope you like it. Court with Krissy is now in session.
Okay, let's go ahead and take up the next matter, which is People versus Shane Boyce. This is file 26-15663-FH. It is the time, date, and place set for a hearing on a motion filed by Mr. Boyce's counsel to withdraw. We have Mr. Boyce with us. Along with Mr. Boyce, we have Mr. Settles, his attorney. We have Ms. Henry here from the prosecutor's office. Mr. Boyce, where'd you go? Well, Mr. Boyce was with us. Hold tight, everyone. Yeah. Mr. Boyce? Well, apparently he had something more important that came up. So let's go ahead and go on hold for a moment. Here he is. All right, Mr. Boyce, please don't get up and leave during the middle of an interview if you or a court hearing without telling me what's going on. All right. Mr. Boyce is here. His attorney, Mr. Settles, is here. Ms. Henry is here for the prosecutor's office. We also have Ms. Henry handling our clerk duties today. Ms. James is our court reporter. We're handling this matter by video conference today. Mr. Settles, I've reviewed the motion. It looks like you were appointed on the 8th of April, and by the 9th, there had already
been it looks fine.
Filed by you. Hold on. I can hear you, Mr. Boyce. Can you hear us?
Yeah, I don't think he can hear us. I think that's the problem.
Okay.
Yeah, I think that relax. It's okay.
All right. Well, that explains. Mr. Boyce, can you hear us?
1 second, folks. Sorry about this. Just having a technical issue.
Okay, let's go on hold then, and we'll restart once we have Mr. Boyce able to hear us. Okay, Mr. Boyce, this is a hearing on a motion to withdraw that's been filed by your court-appointed attorney, Mr. Settles. Mr. Settles is here, as is Ms. Henry. Ms. Henry is our clerk, and Ms. James is our reporter. We're handling this matter today by video conference. Mr. Settles, let's go to you. I noted for the record before Mr. Boyce was able to hear us that you were appointed to this matter following Mr. Burdett being discharged. You were appointed on, I believe, the 8th of April. This motion was filed the next day. If you'd like to go ahead and make any argument, Mr. Settles.
Judge, I think I attached the letter of April 9 that I had received from Mr. Boyce, where he specifically asked me to perform no further work or anything on his case. And I don't think he should be concerned about the billable hours, but he might be concerned that I would prejudice his case. And he notes that there's been a fundamental breakdown in the attorney-client relationship.
Hold on, Mr. Settles. Hold on. That's all right. When you move your head away from the microphone, we lost you. So when you started talking about the attorney-client breakdown, we did lose you. Go right ahead, sir.
Mr. Boyce did reference that there was a fundamental breakdown in the attorney-client relationship, and I would tend to agree. In that letter that I attached, you will see that he complains that I failed to address material falsification of dates in the reporting, choosing to focus on a binary merits argument rather than a vindictive prosecution and due process violations. That is true. When I spoke with him, I concerned myself with the facts of the police report and the facts of a retaliatory prosecution. I don't know if I swore, but I certainly would have indicated I'm not interested in any kind of I don't see any kind of retaliatory action by Kyle Atwood or any other member of the prosecution that they would do something in retaliation for something that anyone does at work. I have no basis for that. And so I was not interested in following that, going down that rabbit hole. And I try cases. I am interested in the facts of the case. And so there you go. And I'm not, certainly I just walked into this thing, and I am not pushing anyone to take a deal. All I'm trying to do is figure out if a guy's going to testify and what he's going to testify to. I've already got the police report and all that stuff, just getting ready for court. Thank you very much, Your Honor.
All right, thank you. Mr. Boyce, I did review the exhibit that was attached. This is a letter from you to the court seeking to discharge Mr. Settles. Was there anything else that you wanted me to know?
Yes,
Hold on. without going into attorney-client privileged materials, conversations between you and your attorney, I don't want you to discuss those, but anything else you want me to know, sir?
If I may, Your Honor, I have a statement of facts that I'd like to bring up to the courts.
A statement of facts. What do you
Yes,
mean?
Your Honor.
What do you mean? Tell me what this is.
This is a statement of facts. So I have formally terminated the services of Philip Settles as legal counsel effective immediately. This decision is based on a fundamental breakdown in the attorney-client relationship under MRPC 1.2. My defense has been actively suppressed and counsel has repeatedly declined to address the constitutional violations identified herein. In effective assistance of counsel, Strickland versus Washington, counsel has refused to investigate exculpatory evidence regarding the retaliatory nature of this prosecution, despite any attempts to present evidence, including documentation of a 3.5 gram methamphetamine purchase facilitated by T&T officers, Equifax records, and official police communications. Counsel characterized these constitutional issues as lacking merit and refused to incorporate them into the defense strategy. This constitutes a failure of zealous advocacy. Evidence of misconduct and due process violations, Brady versus Maryland. I submit the following documented evidence of police misconduct involving Officer Jonathan King.
We're not going to go any further into that today.
Yes, sir.
What we're talking about is whether or not your attorney is able to represent you in this matter. All right, Mr. Boyce, I've heard your argument. Let me go ahead and hear from Ms. Henry. Ms. Henry, do you have anything you'd like to add in this?
Obviously, we're not in a position to force Mr. Settles to stay working with someone where there's a breakdown of communication. The only thing I want to add is that this is his second court-appointed attorney. And I don't, just because he may not like someone's personality doesn't mean that they can't effectively do their job. So I just hope that the court would warn him on that and that he can't just shuffle through all the attorneys that are on the contract.
All right, thank you. All right, so Mr. Boyce, here's where we stand. First, before I even address this, I need to notify you, if you didn't know already, there's a bench warrant for you. That bench warrant is alleging that you have failed to get a urine screen on February 15th, failed to appear for a screen on 3/1, and had a positive urine screen for methamphetamine on 4/8 of 26. I don't know why I'm dealing with a motion from you if you won't even turn yourself in on the warrant that is out there. Have you turned yourself in on this matter?
Your Honor, if I may.
Is that a no or a yes? Have
No.
you been brought in on this? Okay.
No,
So you're asking me to use our procedure to assist you when there's an active warrant against you, and that causes me concern, frankly. It suggests to me that you're perhaps abusing the process a little bit. Further, I'm deeply concerned that you're after about 24 hours of representation by Mr. Settles, that you're seeking to have another attorney brought into this matter. I told you when I agreed to allow Mr. Burdett to withdraw from your case because you had issues with him, that we were not going to play round robin, that we were not going to be going down the list and waiting for you to find someone that you that would accept the arguments that you want to present. The attorneys are there for a reason. They're there to give you their legal advice. You've now got a second attorney apparently that you are having a disagreement with. And while I don't disagree that your concerns are important, I am not of the belief that there's been a breakdown in a relationship that hasn't even really been fully affected at this point. You have an attorney for a reason. That attorney is to address issues relating to the charges against you, the methamphetamine possession charge, a 10-year felony that's against you right now. This is not a whistleblower case. This is not a case, as far as I know, where retaliation is relevant. Perhaps that's something that you can discuss in more detail with your attorney. But I don't have enough information here today that establishes that Mr. Settles has done anything to result in his dismissal here. I think it may well be that you just simply don't like what he's telling you. And that is not a sufficient basis to relieve an attorney. Because frankly, if Mr. Settles is telling you those things, Mr. Burdett may have told you those things, and it's very likely that multiple other attorneys, if appointed by the court, would tell you the same thing. So the bottom line here is I'm denying your motion. I'm not going to relieve Mr. Settles at this time of representation. I'll take that matter up in the future should it arise again. This is not a foreclosed issue. But as far as today goes, I'm not satisfied that you've presented a sufficient case to grant the motion. The motion is denied. Further, I'm requiring that you present yourself to law enforcement in order to be brought in on this warrant. Again, this is an outstanding warrant for your arrest. These are important issues. I'm particularly concerned about the alleged positive urine screen for methamphetamine, when that's the substance that is also alleged that you were in possession of in the underlying felony complaint in this case. So frankly, get yourself before me after you've been arraigned, and we'll discuss that in more detail. Otherwise, you'll
I may
make
state
a whole
one
lot
thing.
worse. Let me go to you, Mr. Settles, please.
Judge, Mr. Boyce has been sending me letters about, because I did send him the bench warrant when I sent him my motion to withdraw. And he would like me to point, I think he wants me to point out that the bond order has not been signed by the magistrate. And so therefore he feels that he cannot be, that the warrant doesn't have any basis, and that the warrant should be set aside, the bench warrant.
All right,
No,
you can bring an
that's not
appropriate
true.
motion, and I'd be happy to hear the motion. But in the meantime, there's an
Thank you,
active
Judge.
bench warrant that does have my signature on it. It's got my signature on it. That's an
Yeah.
order of the court that needs to
Thank
be
you, Judge.
complied with. Do you understand, Mr. Boyce?
Yes, Your Honor, he is falsely
right.
incorrect.
Mr. Settles, if appropriate, I'll certainly entertain a motion at any time with regard to the bond and whether or not there is a
Sure.
bond in place.
Thank you.
But what I can tell you is my order is in place, and I expect that the defendant will comply with it. All right, that's it for today. Thank you, Mr. Boyce. Thank you,
I may
Mr.
state
Settles.
for the record,
Thank you,
please.
Ms. Henry. We're done.
Thank you, Judge.